Today, August 29th, 2008, Mark Arman with VIB TV. I'm here with Robert McConnell. Robert is a Vallejo lawyer with expertise in bankruptcy and a penchant for the process. So we're going to ask Robert a few questions about the bankruptcy proceedings so far and see if we can get an idea of what's happened so far in Vallejo's Chapter 9 bankruptcy and where it's going. So Robert, as far as the bankruptcy is going now, where do we stand?
At this point, the sides have taken testimony. They've made an argument to the judge about whether the motion to admit the case into bankruptcy should be approved. The judge is planning to take some additional comments next week, and will probably enter a judgment, if not next week, then the following week.
Okay, so that's on whether or not the city qualifies to be in bankruptcy.
That's correct. He had some pointed arguments in response to comments made by the union's attorney. But also, most significantly, he directed 3 areas of inquiry to the city attorneys that I believe the city attorneys will need to respond to very carefully. One was whether or not the city was actually insolvent as compared to only the general fund, and that's what the experts have been talking about the last several weeks. Another one was what would happen if the petition is admitted and the union contracts are actually voided, but no plan of reorganization is ever presented. And finally, what if they never present a plan? What then? So I think,
mean if the city doesn't present a plan?
That's correct. So I think actually the judge is saying to the city attorneys, I want a plan for adjustment of debts, and I want it as soon as you can get it to me. I'm not going to be tolerant of delays in this case.
Right, and it seems he's taken kind of the same approach with the unions. They've wanted some delays along the way, and he hasn't been too receptive.
That's true. They've accommodated some vacation schedules during the month of August, but now that we're heading into the Labor Day weekend, and after that, the process will pick up to a very rapid pace until we hit the holidays in the late part of the year. So I'm sure the judge is going to put this on as fast of a track as his schedule will now allow. He's still having to balance this in with his full caseload.
Okay. Now, interestingly, the union attorney, Dean Gloucester, he's been raising a lot of points that seem to me a little bit outside of the legal arguments, and one of the ones that he raised that I think is interesting but also shows it would seem the intent of the unions. He spoke about the need for the city, and I'm paraphrasing, but basically he felt that the city needed to expend everything possible to the point that the citizens felt sufficient suffering to be compelled to vote for a tax measure. What are your thoughts on that? Is that strictly hyperbole that he's putting out there, and what's the reason behind pushing that sort of argument in court?
Well, part of the argument is made not only to the judge, but to your clients as well. Because if the client doesn't hear the attorney making the argument the client makes, the client doesn't think that the attorney is doing the job that the client wants to be done. So part of that argument may be for the benefit of that particular attorney's clients. You have to recall, though, that in Chapter 9s, at least, the judge in the court does not get to take the place of the legislative body. So they cannot step in and say, well, as a legislature, you should have done this, you should have done that. To the extent that they can even address that concern, it will have to be phrased in whether the actions are in good faith.
Now when you're referring to that, is that kind of a reference to some of the claims the union's legal counsel has made that the city has mismanaged itself in the past, and they should have done things with revenue, or they should have sold other assets, or they should have collected bad debts? Is that the kind of...
Well, that's always the would have, could have, should have argument that everybody makes. Of course, we all look back and think we could have and should have and might have done things differently. The reality is that you can't ask the judge to second-guess a legislative body. They have the authority, and the judge does not. That much is very clear in Chapter 9 law.
Okay. Now, as we're getting close to a judgment, obviously it can more or less go 2 ways as far as I understand it. The judge can either say, yes, I rule that the city qualifies for bankruptcy, and the second part of that would be that the judge rules that the union contracts should be voided because they are burdensome. The flip side would be the judge says, no, you don't qualify for bankruptcy, and no, you don't meet the requirements to void the contracts. Go back, take action to get yourself out, and don't show up again unless it's really bad. I mean, am I understanding that correctly?
You are doing that correctly, and I think that the judge will rule upon the application to admit Chapter 9 into the court and probably we'll see a decision on that part of the case very soon.
Okay. Now, let's just look to the future a little bit. If the judge rules that the city qualifies for bankruptcy, part one, and he rules that the contracts are burdensome and that they should be redone, rewritten, or opened, however you want to phrase it, what recourse does that leave the union? In other words, can they appeal this thing? Can, for example, the retirees initiate a class action suit?
Well, an appeal can certainly be taken by the unions or the city if the decision goes against them. Appeals in bankruptcy court are much faster than in the state courts. There's a limited time period in which the notice of appeal can be prepared. After that, you have to have the court reporter's transcript prepared. That can be a considerable delay in a normal case, but in this particular case, the dailies have been requested. The transcripts are actually available on the web page for the city, and it would take very little effort for the court reporter to put those transcripts into a volume. In addition, each side would have to order the clerk's transcript as well. Once those two transcripts are prepared, it's transmitted to the bankruptcy appellate panel, which will then give a briefing schedule, and after that, a hearing date. Now, the bankruptcy appellate panel is normally located in Pasadena. However, they can come to Sacramento if they choose to do so. Or both sides could stipulate to either bypass the bankruptcy appellate panel, go directly to either the district court, which is still another trial court, or directly into the Ninth Circuit. The Ninth Circuit, of course, would take much longer to decide the matter because of their caseload.
Okay.
But certainly any side can appeal. It's a matter of right.